All right, the state is alleging 3 charges against you. One of is an aggravated DUI. It's a felony allegation. The second is a dangerous drug possession or use allegation, a felony. And the third charge is drug paraphernalia possession or use, a felony as well. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for a preliminary hearing on the 10th of November at 4:00 p.m. The preliminary hearing is to determine if there's probable cause to charge you with those 3 felonies. Not convict you, just charge. If probable cause is found, then your case will bind over to the Gila County Superior Court. If probable cause is not found, one or all of those charges will be dismissed. Your release conditions are as follows. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if your address changes. Do not leave the state of Arizona without permission of the court. Do not possess or consume any alcohol or drugs without a valid prescription, and not to possess any firearms. Do you understand those release conditions?
Yes, sir.
All right. I'm placing a $2,500 bond on you, so you remain in custody unless you post bond. Being that you're remaining in custody, you have the right to a court-appointed attorney if you cannot afford to hire one. So I'll provide you a financial statement to complete that if you wish to have a court-appointed attorney and you financially qualify, they'll be assigned to your case. Being also that you're held in custody on the felony allegations, the county attorney is required to file a complaint on you within 48 hours of the date and time of this hearing. If they fail to do that timely, so that would be on Friday at 1:15 roughly, 1:25 roughly, if they don't file the complaint, you'll be released on your own recognizance without having to post bail, okay? The prosecutor can file the case up to 7 years from the date of your arrest if they don't file the complaint. Do you understand that?
Yeah, may I say something?
Yes, in one moment, not right now. Let me just get through the formal process and then I'll hear what you have to say, okay? Also, you have an attorney that is strictly assigned to review your bonds. It's not to represent you in the case, only to review your bonds. So what will happen is the information will be sent to the office, the attorney's office, to review the bond. If they find that the bond is unreasonable at $2,500, they'll request a hearing and you'll be notified of that. If they don't find that, then there will be nothing heard. We'll just wait to see if that 48 hours passes or not. If a complaint files, you qualify for the court-appointed attorney, they'll be assigned at that time. Okay, what did you have to say?
For one, I got hit by a car 2 months ago,
Okay.
and I'm undergoing doctors tomorrow. I'm supposed to have an MRI of my brain and my neck.
Okay.
And whenever I seen you and you sentenced me for the driving on the suspended, and I showed you my license and everything, you told me that that my payments didn't start until December 29th, and they're saying that my license got suspended because I did for financial obligation, but you told me not until December 29th was I supposed to start payment. And the DUI, I passed all of the sobriety tests for the officer, and I even did a blood test. I wasn't on anything.
Okay, so there's many reasons why a license can suspend, okay? It doesn't mean because I told you not to make a payment until the 29th. I can't remember. I've had 50 cases since I've seen you. So just because you didn't make that payment doesn't mean your license suspended because of that, okay?
Is there any way that you can reconsider the bond, because I'm going to doctors, like I'm undergoing doctor's treatment from getting hit by the car. Okay,
the problem is you're undergoing doctor's treatment because you're hit by a car. You were in custody not too long ago, out of custody, and you have these allegations of felonies.
And I showed up to every court date, sir. I really need to see my doctor. Re-injured my old brain injury. I didn't miss any court dates. I came to court. I live with a retired officer.
Okay, so let me address and get to the truth of what you're saying. You did miss court dates. I've got them right here.
When?
I'll tell you. April 30th of 2025, you failed to appear on a case that was out of this court as a failure to appear.
April 20th.
April 30th.
April 30th.
There was a failure to appear on a case. I didn't only use that for your prior failure to appears, and there's some that are older than 2 years, so I didn't really look at that too
25
close.
years.
Right, there's some other ones in there, but the one that I saw, a recent one in April 2025, that's
I don't
one
remember
factor.
that one. I don't remember that one, and I showed up to every other one. I might have been in the hospital
The
or
problem
something.
is, the other component is that I used, it's not just that, is that what you mentioned, you were sentenced to here not too long ago and pled guilty to some charges. You have in April, assault under disorderly conduct.
The assault got dropped.
The
All I had was disorderly and no insurance or registration. Those are the only ones I got sentenced on.
Okay, and then in June of 24, allegations, possession of marijuana and DUI, and then there's
Those got dropped.
Okay, so when you say dropped, they don't go away. Okay, so this is the court, so make sure you don't try to pull something that's not accurate here.
I'm not sure.
All right, what I just told you on these charges, if these charges don't file within 48 hours, they don't drop. Make sure you're clear of that. They can file up to 7 years. It just means they are not prioritizing that case. So they don't just go away and are gone and, hey, I'm done with it. That is not the case at all. The problem is when you're out on your own, you're reoffending. You're committing more crimes, at least alleged. That's the problem. Not that you have the doctor's appointment and all those other things. It's when you don't have the doctor's appointment and you have your own time, what you're doing.
I was in somebody else's car.
Ma'am,
I understand.
I'm not going to have a trial right here. This is the wrong case for time for you to be given details of the case. My job is to help you protect your rights, and every time you throw something out like that, you're not doing yourself any good. You're not protecting your own. This is the part where you don't want to give details of the case.
Yes,
Okay?
sir.
This is to inform you of the charges,
Yes,
let
sir.
you know that you have 3 felony allegations, and I only set the bond at $2,500.
Yes, sir.
It could have been $20,000, okay? But I looked at the whole circumstances. The risk is that when you're out on your own, you're committing violations, and that's why it's only $2,500. Maybe that'll hold you, that if you post that bond, whoever posts that bond will make sure that you don't commit any crimes. That's what that does. If you do, people will lose that bond.
Is it bondsman eligible?
Yes, it is.
So it would be
There's no
$250 on
restrictions
the
it.
bond?
Yes, as long as you have the collateral, whatever the agreement is on that.
Okay.
Any questions on
No,
that?
sir.
Okay. So I'm going to get a signature on this release order for you, where it says dependent of the information we just discussed. I'm also going to provide you a copy of the financial thing that if the complaint does file, you can have a court-appointed attorney. So I can get a copy of each one of those. Yes, sir. I'm sorry, Gary, one more of this too, please. This is the other form is going to be the attorney that's assigned for the bond only that I told you about. If you qualify for a court-appointed attorney and they file the complaint, that attorney will be different and they'll be assigned if that complaint files. You may get out on your own recognizance after 48 hours if they don't file the complaint, so keep that in mind before you put too many efforts of trying to come up with the $2,500.
I have an appointment at Banner Health tomorrow for an MRI. Am I going to be able to go?
If you post bond, yes. If that won't be the 48 hours to see if that goes or not. So if you post bond, that answer is yes. If not, the answer is no.
So if I stay in jail, are they going to make sure I get to my doctors, because they're not giving me all my
No.
medications?
No.
They're not giving me my medications.
If you have medications and all that, you can make arrangements. You have a family member here.
It's here. It's here. They have it in the jail, and they refuse me give me my medicine for my brain aneurysm.
Okay, well, I can't tell how they do their procedures and policies, so if you have required medications, then they'll do what they do according to their policies, okay? Anything else?
Nope.
Okay, thank you. Ms. Gorman, can you come forward? How are you?
Could be better.
The state is alleging one violation against you, which is the assault charge under domestic violence. On that charge, you have the right to remain silent, right to counsel, and right to trial. It's a misdemeanor violation allegation. I've scheduled you for an arraignment on the 26th of November at 9 o'clock in the morning. The arraignment is where you'll need to be prepared to plead either guilty, not guilty, or no contest to that charge. Depending on how you plead will be what happens next with the court proceeding. All of those options, as well as the penalty range, will be explained to you prior to giving your plea, okay? Your release conditions are as follows. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if your address changes. Do not leave the state of Arizona without permission of the court. Do not have any unwanted contact with the alleged victim. So what that means is, I'm not restricting you guys to not talk to each other. But if the victim, alleged victim, wishes not to talk to you, you must comply with that request.
Okay.
If you don't listen to that request, you could be violating my order and you could be arrested or a warrant for your arrest.
I understand.
You understand that?
Yes, sir.
I'm not restricting you from going back to the residence, so you're allowed to return if you wish.
Okay.
I am going to order you to pretrial services. So what that means is when you're released from custody, I'm going to provide you with a name and phone number to the probation department. You're not on probation, but you are on release services. They're going to monitor you to make sure you're obeying these release conditions and that you're showing up to court all throughout the court process, and they'll give you instructions.
Okay.
So that will be provided to you. Can you comply with those release conditions?
Yes, sir.
All right, and you'll show up to court as ordered?
Yes, sir.
Okay, I'll release you on your own recognizance. Do you have any questions?
No, sir.
No? All right, I need the signature here where it says defendant. And then another signature on this. This is the name and phone number for the person to contact. We'll get you copies of that, and as soon as we get those copies squared away, you'll be all set. Okay? Yeah, how long roughly before you have released?
30 minutes usually.
Okay, so about 30 minutes. The sheriff's office is right next door here if you're wishing to give a ride or whatever.
Sir, is she allowed to leave this county or does she have to stay in this county?
She can go in any county she wants. She can't leave the state of Arizona without permission.
Okay, because I was gonna see if maybe she could come home with us for a little bit until it's time for her.
As long as she's in Arizona, that's fine.
Okay.
Can I see the probation one again?
He's way faster than me. I'm just pacing down.
Yeah. Yeah, so about a half hour or so. Do you know where the sheriff's office is? Yeah, directly across the street. There's a bench out there. You're welcome to wait in our lobby instead of wait outside. Whatever you want to do. In about a half hour, she'll be released, and you guys can have her.
Thank you so much, sir.
You're welcome.